Hello, I'm Sarah Hopkinson. I previously co-authored a blog on identifying the correct defendants in RTA cases. I'm now bringing my colleague Holly Burkett on board so that we can provide this short webinar covering the correct defendants in RTA cases, but with a couple of post-Brexit updates and also the inclusion of foreign insurers. On the screen now is a list of the potential defendants in RTA cases. I'll be covering the tortfeasor, the Road Traffic Act insurer, the Article 75 insurer, and one half of the MIB stuff, with my colleague Holly Burkett picking up the other stuff. So let's start with the obvious, which is the tortfeasor. Where the negligent driver is known, insured, and driving in a personal capacity, the claimants can issue against a negligent driver as the only defendant. Where there is a contractual insurer, it's unlikely to be necessary to name both the driver and the contractual insurer, so pick one. What I do flag is that if the tortfeasor's insurer has not confirmed pre-issue that its capacity is as contractual insurer, or if you foresee potential issues vis-a-vis the tortfeasor and the insurer, then including the insurer in the proceedings from the off, particularly if limitation is close or calling, then doing that and pleading the insurer's alternative contingent liability, more on which later, is likely to be the safest course. Bear in mind that in a scenario where the tortfeasor is driving in the course of their employment, the employer is likely to be vicariously liable for the individual driver, and therefore it is the employer, the company, that ought to be named as sole defendant in place of the individual tortfeasor. And of course that makes sense because it'll be the employer who holds the relevant policy of insurance. There ought to be an insurer. And I say that because it is mandatory to have insurance, and we find the rules on that from section 143 and 145 of the Road Traffic Act, which I don't regurgitate, but I put there on the screen. So there ought to be an insurer in most cases. It's a question of identifying the insurer and identifying the capacity of that insurer in any case.
I'm going to talk to you now about the contractual insurer. As Sarah has already pointed out, insurance of a motor vehicle being driven on a road or other public place is mandatory under section 143 of the Road Traffic Act 1988. Therefore, in most circumstances, you will probably have a contractual insurer who agrees to indemnify their policyholder, the tortfeasor, for any road traffic accidents that they are involved in. And in those circumstances, when you're pleading your case, reliance will be placed on the European Community's Rights Against Insurers Regulations 2002. Because as we all know, Regulation 3 gives a direct right of action against the insurer if certain requirements are met. Now, what are those requirements? The first three are set out in Regulation 3. You have to have an entitled party who has a cause of action against an insured person in tort. The cause of action has to have arisen out of an accident, and the insurer must have issued a policy of insurance relating to the tortfeasor's vehicle. There is another requirement. This comes from Regulation 2, and it is that the tortfeasor's vehicle has to be normally based in the United Kingdom. What Regulation 2 also defines is an entitled party. So looking now at Regulation 2, we can see that an entitled party means a person who is a resident of a member state or an EEA state. As the 2002 regulations are UK legislation, they obviously remained as they were post-Brexit. However, as we can see from the definition of entitled party, the regulations unamended posed a problem for those wishing to sue a contractual insurer, because they fell outside of that definition of an entitled party. Therefore, the 2002 regulations have since been amended by the Motor Vehicles Compulsory Insurance and Rights Against Insurers Amendment EU Exit Regulations 2020. And they were amended to ensure that UK and Gibraltarian residents continue to be able to make claims direct against UK insurers. And we can see there from Regulation 3, what they did was introduce the words UK or Gibraltar after member state in that section 2 definition of an entitled party. Practically speaking, you are still able, therefore, to plead the 2002 regulations as giving rise to a direct right of action against the insurer. However, if you do have any concerns, you would simply be able to add as amended by motor vehicles, regulations, etc. in brackets afterwards. Now, just to be clear, this amendment came into force on IP completion day, which was the 31st of December 2020. And so there's a continual right to sue insurer directly under the 2002 regulations, both before and after IP completion day. I must state, though, it is crucial to ensure that there aren't any indemnity issues between the insurer and the tortfeasor before naming the insurer as the sole defendant, because if they aren't going to indemnify their policyholder, then they are not a contractual insurer, and the claim therefore will fail without any amendment or addition. Therefore, as I've said, if there are any concerns about indemnity before you're issuing proceedings, it would be prudent to sue both the tortfeasor as the first defendant, in addition to the contractual insurer in the alternative, and also to consider whether there are any other contingent liabilities that you might want to plead, one of those which Sarah is going to cover now.
So the Road Traffic Act insurer will be in place in circumstances where the insurer is not the contractual insurer. This is a contingent liability scenario, so you will need to name both the tortfeasor, usually as first defendant, and the insurer as RTA insurer, usually as the second defendant. Section 151 it is what applies here, and this is where the liability of the tortfeasor is required to be covered by a policy of insurance, and the liability is covered by a policy and the tortfeasor is insured on that policy, or it is a liability other than an excluded liability, which I'll address later, which would have been covered if the policy insured all persons. So what this means in practice, in reality, is there's a policy in place that covers the use of the vehicle at the time of the accident. For example, the particular vehicle had a policy of insurance for social, domestic and pleasure use, and it was being used for SDP at the time of the accident, or it specifically covered private hire and was being used for private hire at the time of the accident. In that scenario, if the use is covered, then even if the individual tortfeasor was not insured on the policy, but their identity is known, the insurer of the vehicle will be the Road Traffic Act insurer. Section 151(5) sets out what is covered. In short, we're concerned here with death, personal injury, property damage, and costs. There are some maximum amounts of property damage which can be found in subsection 6, which I haven't put on the slides, but I invite you to read section 151 in full in any event. And the reason I say that is it sets out quite clearly the extent of the duty, and coming back to excluded liability, which I referenced before, in section 151(4, it explains that excluded liability is a claimant who allowed themselves to be a passenger in a vehicle which they knew or had reason to believe was stolen or had been unlawfully taken. But like I say, read section 151 carefully before determining that the insurer is likely the Road Traffic Act insurer, and also look at section 152, which includes a number of exceptions, the most common or notable of which is the need to notify. And if the notification doesn't take place, the RTA insurer will be able to avoid their contingent liability. You are required to notify the insurer of the bringing of proceedings either before they are brought or within 7 days of bringing them. Up next is the Article 75 insurer. One finds the Article 75 insurer coming into existence from the MIB's Articles of Associations, and I've put there up on screen what the Articles of Association say. This is the next level down in the hierarchy for claimants because it only covers uninsured losses. So, for example, if the claimant is driving a vehicle for which they hold comprehensive insurance, i.e. damage to their own vehicle is covered by their own insurer, that's not something which the Article 75 insurer is going to be liable to pay because it only is in relation to uninsured losses. This is also a contingent liability. So as with the Road Traffic Act insurer, the Article 75 insurer needs to be named as normally the second defendant, with the tortfeasor also in the proceedings, normally as first defendant. So the Article 75 insurer is an insurer who is not otherwise the contractual or RTA insurer, obviously, but they issued a policy of insurance in respect of the relevant vehicle. In that scenario, the insurer is required to stand in the shoes of the MIB. And in practice, where you're most commonly going to see this is where the policy did not cover the particular use of the vehicle at the time. For example, the tortfeasor, whether or not they're the policyholder of the insurance policy, was using a vehicle for private hire, when only social, domestic and pleasure uses were insured on the policy.
I'm now going to give you a brief rundown of the MIB's Uninsured Drivers Agreement. It's already been touched upon briefly in respect of Article 75 insurers, who of course take the place of the MIB in certain circumstances. As the name of the agreement suggests, it is for uninsured drivers. It is also for uninsured losses, same as Article 75. So again, we're talking about personal injury, property damage or credit hire, assuming they aren't otherwise insured. Now, claims under this agreement can be started in the County Court or High Court as normal. The agreement does not give you a cause of action against the MIB, though. Their liability, like an Article 75 insurer, is contingent on the liability of a tortfeasor being established. However, because the MIB wants to be able to participate in proceedings as if it were a normal party, what you'll find in Clause 13 of the Uninsured Drivers Agreement is a requirement that the MIB be included from the outset of proceedings. Otherwise, they don't have any liability to satisfy an unpaid judgment. There is an exception, and that's if the claimant reasonably believed there to be a policy of insurance in place. But I would thoroughly recommend that you go and look at the wording in Clause 13 to understand the scope of that exception. Therefore, when proceedings are being issued, you have to sue the tortfeasor, normally as the first defendant, and also issue against the MIB as the second defendant. And in doing so, you need to plead that you're seeking a declaration as to the MIB's contingent liability. The MIB has helpfully provided a template wording which they ask that you include in proceedings when they are being brought in under the Uninsured Drivers Agreement. That template wording can be found in the notes for guidance for this agreement. It's accessible on their website, and the exact wording is included under Clause 13's notes for guidance. Use it. Some exceptions do exist to the scheme. They can be found in clauses 4 to 10. For example, you cannot sue the MIB for losses caused by a Crown vehicle or one accepted from insurance by Section 144 of the Road Traffic Act 1988, such as county council or police authority vehicles. So please, as I said earlier, do refer to the wording of the agreement for notable exceptions. They are accessible on the MIB's website. Very briefly, you may recall the case of Lewis and MIB. The citation is on the slide. It was a case concerning an accident with a motor vehicle that was being driven on private land. And as we know, Section 143 makes it compulsory for a motor vehicle to be insured on a road or other public place. But Mr. Lewis, in this case, was seeking to recover damages from the MIB for the accident that happened on private land. So in the circumstances, it seemed as though there wasn't a legal obligation for the MIB to satisfy the judgment. The Court of Appeal upheld the first instance decision, finding that the EU directive, the 2009 Motor Insurance Directive, which required compulsory insurance of motor vehicles regardless of where they were driven, had direct effect against the MIB, as it was considered to be an emanation of the state. And therefore, they were required to compensate Mr. Lewis for the government's failure to implement in full a compulsory insurance regime which covered use of vehicles on private land as well as public. Now, I only mention it in passing because following Brexit, we have now got the Motor Vehicles Compulsory Insurance Act 2022. That was introduced by Parliament and effectively reverses that decision in Lewis. It inserts a new section into the Road Traffic Act 1988 and restores the pre-Lewis position that liability in respect of the use of vehicles is only relating to motor vehicles being driven on a road or other public place. Therefore, if you're faced with a case where an accident happens on private land using an uninsured vehicle, you cannot pursue the MIB. You must sue the tortfeasor or anybody who might be vicariously liable for their actions, and just hope that they have the capacity to meet any judgment.
Finally, from me, very briefly, is the untraced drivers scheme from the MIB. The clues in the name. This is when the identity of the tortfeasor is unknown. These are untraced drivers. A claim is not issued in these scenarios in the courts if the identity of the driver is unknown, even if you know the identity of the vehicle and that vehicle was insured. and authority for that proposition comes from Cameron and Liverpool Victoria Company Limited, the citation of which is on the slide now. The Untraced Drivers Scheme is a safety net for innocent victims of actions of unidentified drivers. It's funded from levies charged upon the insurers by the MIB. Those levies, in turn, are going to come from premiums paid by us, members of the public. The time limits that apply to bring a claim directly to the MIB, remember, not at court, are the same as those found in the Limitation Act in relation to personal injury and property damage claims. And the MIB determines the claims using their own portal and also assesses quantum. So there's no involvement from the court at any stage.
The last topic I'm going to cover is foreign insurers. Now, imagine this scenario. You have a client who is habitually resident in England. They have a road traffic accident with another vehicle in England. However, the tortfeasor is French. His vehicle is registered in France because that's where he normally resides. And he's just popped over on the ferry for a day trip. So it's likely that his insurance is also being provided by a French company. Obviously, substitute French for any other foreign national. In that situation, you cannot rely on the 2002 regulations to sue the insurer as a contractual insurer, because that vehicle which was involved in the accident is not normally based in the UK. You might recall from my earlier slide that that was one of the requirements that I outlined needed to be satisfied in order to sue under the 2002 regulations. Before Brexit, we had the recast Brussels regulations and the Lugano Convention, and they provided a cohesive set of rules across the EU and between EU and contracting EFTA states to provide both a direct right of action against a foreign insurer and the possibility of enforcing any judgment obtained in one signatory state against a foreign insurer who was residing in another signatory state. Unfortunately, once Brexit happened and the IP completion date passed, neither the Brussels regulation nor the Lugano Convention will apply. However, all hope is not lost. What we still have access to is the Rome II regulation. That was retained by the very pithily worded, the law applicable to contractual obligations and non-contractual obligations, amendments, etc., EU exit regulations. Now, Rome II has, in Article 4, provisions for the applicable laws in relation to non-contractual obligations, such as a tort. I'm not going to read out the 3 paragraphs that you can see there on the slide, but what you can gather from the first paragraph is that the starting point, the law applicable to the tort, will be the laws of the country in which the damage occurs. So in the example I gave earlier, the damage has occurred in England, and therefore the applicable laws will be those of England. Paragraph 2, as you can see, provides for an alternative applicable law, and that is where the person who is sustaining the damage and the person who is claimed to be liable both have their habitual residence in the same country, which is a different country to the one where the damage occurred. Again, with the example I've given, that doesn't apply because the person injured resides in England and the person claimed to be liable resides in France. So paragraph 1 would take precedence and the applicable laws would be that of England. The last paragraph, as you can see, allows for the laws of a different country to take precedence over the damage, location and the habitual residence of the 2 parties involved, where it is clear from all the circumstances of the case that this alternative place is manifestly more closely connected to the tort. That is normally through a pre-existing relationship. So just to be clear, what Article 4 does is identify the law that is applicable to the non-contractual obligation. In our example, because we are saying that the English law is the applicable law, that means that we don't have a direct right of action against the foreign insurer, as I previously explained. As you see on the slide, I've put up Article 18, and Article 18 confirms that a person may sue an insurer of the person liable in situations where the law applicable to the non-contractual obligation, i.e. the tort, or the law applicable to the insurance contract so provides. In other words, it doesn't grant a direct right of action, but it confirms that if one exists in the law applicable either to the tort or to the contract, that it can be relied upon. So if we're talking about an accident in England, we are probably going to be applying English law to the tort. The crucial point here is that Article 18 gives the alternative the ability to apply the foreign law applicable to the insurance contract, if such law permits the claimant to bring a direct right of action against the insurer. That means that in theory, different laws might be being applied to the tort and the contract of insurance. This appears to be the interpretation that's given by the European Court in the case that I have identified on the slide, Prulifray v. Brodnik and AXA. To put it another way, the nature and the extent of the judgment which an insurer might have to meet vis-à-vis their insured's liability is governed by the laws of England, the laws of tort, but the ability to pursue the insurer in the first place is a law applicable to the contractual relationship between the insurer and their insured, and therefore that could stem from a foreign law. By way of example, if the tortfeasor is from an EU member state, as I identified in my example earlier, in the same way that the UK had to introduce regulations to provide for a direct right of action against insurers, all EU member states would have also been required to implement a direct right of action against motor insurers. So all you need to do is find out what that right of action is. For instance, is it enshrined in statute? And then in theory, you should be able to avail yourself of that direct right of action pursuant to Article 18. The reason I say in theory is because I haven't seen this use of Rome 2 in practice, so I can't comment on the success of the argument. However, the wording of Rome 2, as I've just read out, and the interpretation given by the European Court does lend itself to this interpretation, in my opinion. However, out of an abundance of caution, if you're going to the effort of suing a foreign insurer outside of the jurisdiction, you should probably also be suing the tortfeasor as well, in the event that the claim against the insurer doesn't succeed. But as ever, if you are succeeding against a tortfeasor only, it has the potential issue of them not being able to satisfy any judgment that you may get against them. In summary, Rome 2 provides an argument that the claimant can avail themselves of a direct right of action against an insurer where the laws relating to the contractual obligation provide so. Bearing in mind that if the accident is happening in England, you're probably going to be arguing that the laws of England govern the tort. If you aren't seeking to apply the English laws to the tort, for instance, because the accident has happened abroad, then there might be other challenges, such as the suitability of the English courts as the proper forum for hearing the claim. And again, even if you are seeking to apply English law in the English courts, difficulties might arise because inevitably you're going to be serving proceedings outside of the jurisdiction, and that obviously requires permission of the court to do so. That, however, is not something I'm going to be covering in this webinar. For the purposes of this webinar, it suffices to know that Rome 2, in theory, permits a claimant to sue a foreign insurer directly in circumstances where the law governing the contract permits this. Thank you very much for listening, everybody. I hope you found this webinar helpful. If you have any questions arising out of anything either Sarah or I have said, please have a look on the slide. Our contact details are there for your use. If you don't want to contact us directly, that's okay. The next slide has the details of our clerks on there. Please just get in touch with them. Thank you very much.